Next case to come before the court is Procentury Insurance Company, Evanston Insurance Company. You gentlemen here for that?
We're both here.
Okay. And we're ready to go, but I just want to make sure, I don't know if you have any clients or anybody you're expecting to come to the argument. Okay, then come on. All right, as I said, this is Evanston Insurance Company versus Procentury, and each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes. So just please let me know.
Absolutely. May it please the court, my name is Cliff Mash, and I'm here on behalf of the appellants, which would be Barrett Construction Company, which is a insured Procentury, and was involved in 2 litigations in which Procentury did decline to provide a defense. And I also represent Evanston Insurance Company, which took a judgment in the 2nd litigation against Barrett. And as it relates to the cause of action before this court, Barrett and Evanston sued Procentury. Evanston asserted a claim under the supplemental complaint in order to recover the judgment obtained against Barrett, and Barrett has asserted a claim for breach of contract and bad faith. May I reserve 3 minutes for rebuttal? Your Honor, while this case has admittedly a bit of a convoluted history in that it involves 3 separate cases, really the issue before this court is pretty narrowly framed, and the prism by which Your Honors must view this court is going to be very limited. The trial court granted a judgment on the pleadings filed by Procentury that was based on not only against our complaint, but also on a cross-claim filed by Procentury for declaratory judgment. Both of those rulings were judgments on the pleadings, so as a result, the entirety of the analysis that this court has to do as it relates to this appeal is, what did the pleadings say? And it can't go beyond that. As it relates to both determinations that the trial court made, it's important to note that the trial court acknowledged that pursuant to the pleadings filed on behalf by the plaintiffs in this case, it was alleged in the pleadings that Mr. Shannon Green, the injured party that gave rise to all this litigation, was at the time of his injury working as an independent contractor retained by and working for subcontractor Patrick Electric. That's what our pleadings stated. And in response to those pleadings, Procentury indicated that it acknowledged that Patrick Electric was a subcontractor, but it didn't have sufficient knowledge to admit or deny the remaining allegations. And obviously, we're entitled to have the pleadings accepted by the court in the context of a motion for judgment in the pleadings as being correct and accurate. So the trial court acknowledged that we made that representation in the complaint. And accepting that pleading, the court then went on to take a look at, let's look at the sole basis that Procentury relied on to deny coverage in this case, which is its independent contractor exclusion that was contained in the policy. And the court looked at the independent contractor exclusion and conducted what the court indicated was a Boolean analysis. I'm not proud enough to admit to the court I didn't know what Boolean meant. I had to look it up in the dictionary, and it's essentially an algebraic kind of construction of language based on conjunctives such as and, or, and things along those lines. And in the court, looking at this relevant language, and if the court wants to look at the language we're all looking at, you can go to page 8 on the appellee's brief, just so we're all looking at the same language. The court said, well, the first relevant phrase contained in the exclusion is any independent contractor. And the court said that means any independent contractor. And in the complaint filed by my clients, we admitted that Shannon Green was an independent contractor. And the court kind of indicated, on this alone, I could conclude there's no coverage, but the court goes on. And the second element it looks at in the phrase that it says, or the employee of any independent contractor. So that means obviously any independent contractor or its employees. The court acknowledged that, then the court acknowledged the reality of what our argument was, which is that we contend that Shannon Green was an independent contractor retained by Patrick Electric, not an independent contractor retained by Barrett Construction, who was the insured to the policy. We submit that that makes a difference because the language in the exclusion says bodily injury to independent contractor or employee while such independent contractor or employee are working on behalf of any insured. So we submit that it becomes important to make a determination who that independent contractor who sustained injury was working for in order to determine does they fall within the exclusion. The trial court disagreed. The trial court said that it doesn't make any difference as to whether or not Shannon Green was working on behalf of Patrick Electric or Shannon Green was working on behalf of Barrett. Because the court came to the conclusion because Patrick Electric is an independent contractor, we all acknowledge that, and Patrick Electric was working on behalf of Barrett, the insured under the Procentury policy, that therefore any independent contractor injured on the work is excluded under the terms of this exclusion. We submit that this analogy or this analysis put forth by the trial court is faulty. Number one, it's faulty from just a plain language wording of the policy. The court completely ignores the language in the qualifying language in the exclusion that says, while such independent contractor or their employees are working on behalf of an insured. Those words have to be given meaning. They can't be read out of the policy. You know, based on the court's construction of this, that all that Procentury had to prove was that Patrick Electric was an independent contractor working on behalf of Barrett, and that as a result of that, any other independent contractor who gets hurt is not covered under the policy. If that's accepted, then this hypothetical would be excluded as well. Let's say that Shannon Green, rather than being retained by Patrick Electric, was retained by one of the property owner that was on this construction project, Lakeview Estates, which was the entity that hired Barrett. Let's say while this construction is going on, Lakeview Estates, the owner, hires an independent contractor, separate and apart from its contract with Barrett, to do some landscaping work while the project's going on. Because Shannon Green would be an independent contractor to Lakeview Estates, if the court's construction is accepted, then even if he gets hurt in his capacity as an independent contractor to Lakeview Estates, doesn't make any difference because there was an independent contractor on the site who was retained by Barrett. We respectfully submit that the trial court got caught up in its bowling analysis and failed to give credence to the plain language of the exclusion.
Now, could you interpret that exclusion to actually go so far as I think what they may be arguing is that as long as he was there working on the project, he was working on behalf of the insured?
The court didn't, admittedly, that was an argument by Procentury. The court didn't even address that. The court said it's irrelevant who he's working for. But I submit that construction is belied or can be challenged by a number of provisions that are Ohio law construction provisions. Number one, we're dealing with policy language, and we're dealing with the application of an exclusion. So under that analysis, Procentury has the burden to show that the exclusion applies. If there's any ambiguity, meaning that if that exclusionary language can be reasonably interpreted to mean two different things, the policyholder is entitled to a favorable construction in favor of coverage. So my client, Barrett Construction, I would respectfully submit that when the policy language speaks in terms of working on behalf of, they're talking about a contractual relationship. There was no contractual relationship based on the pleadings submitted before the court between Barrett Construction, the insured to the Procentury policy, and Shannon Green, who we claim was an independent contractor who was retained by Patrick Electric, a subcontractor retained by Barrett. We also submit that if this court considers standard law that deals with the responsibilities or liabilities that flow in the contractor, subcontractor, subcontractor relationship that takes place in all construction projects throughout Ohio, the liabilities or responsibilities only flow where the contracts exist. A contractor who retains a subcontractor under a contract, and that subcontractor then retains a sub-subcontractor, the contractor has no rights against the sub-subcontractor, and the sub-subcontractor has no rights against the contractor. The rights flow from the contracts that are in existence. And in this case, the pleadings were that the contract, the responsibilities flow between Patrick Electric, the subcontractor, and Shannon Green, who we claim was essentially a subcontractor retained by Verity. So number one, I think the position that is advocated by Procentury overlooks the normal, rational, contractual relationships that exist in the world of construction contracts and how obligations and responsibilities flow in that chain. I also submit that the case law supports our position. Now, Procentury has cited a number of cases before this court, and I will represent to the court that they all stand for the proposition, and I'm not going to argue against that proposition, that where you have a subcontractor and their employee is hurt, then the independent contractor exclusion applies. That is correct. That's the way the exclusion works. That's not the facts that we have in this case. Our argument is that Patrick Electric, the subcontractor who was working on behalf of Verity Construction, did not have an employment relationship with Shannon Green, that he was a subcontractor and working in the capacity as an independent contractor.
Well, what does the complaint allege as it relates to that?
The complaint alleges that Shannon Green was an independent contractor retained by Patrick Electric. That's what our complaint alleged. And it alleged that Shannon Green sustained his injuries while he was working in his capacity as an independent contractor working on behalf of Patrick Electric. Those were the allegations before the court.
In the prior litigation, was it alleged that Shannon Green was an employee of Patrick Electric?
In the first litigation, Your Honor, in the Shannon Green versus Verity Construction Lakeview Estate, his allegation was that he was an employee.
Is that at all relevant to the final determination in this judgment entry?
It's not, because it's not part of the pleadings, number one, Your Honor. And we submit that there was a reason why that wasn't a contested issue in the first case. Because what happened was Patrick Electric didn't fight the workers' comp lien because Shannon Green was supposed to get his own workers' compensation insurance. He didn't. And the law in Ohio is that even though there's not an employment relationship, you can still be responsible for workers' compensation if you hire somebody and don't make sure that he has workers' comp insurance. That's the reason why that wasn't litigated in the first case.
Counsel, I'm just going to interrupt you, so you're starting your rebuttal time,
Okay.
so you only have 3 minutes left.
I will go ahead and reserve my time. Thank you, Your Honor.
Morning, Your Honors. May it please the Court, I'm David Lester here for Procentury Insurance Company. I agree with my colleague, Mr. Mash, about one thing, which is that there's really a narrow issue here. And I think he's done a nice job trying to make it seem complicated, but it's really pretty straightforward. It involves a single policy exclusion. It excludes coverage for injury to any independent contractor or the employee of an independent contractor while working on behalf of an insured, here veered. The point of the exclusion is that injuries to contractors or their employees are not covered. There are numerous courts cited in our brief that have held that this exclusion is clear and unambiguous. And there's nothing in the exclusion that mentions a contractual relationship. The operative term is working on behalf of the insured. And what I think is missing from Evanston's analysis here is that Veard was the general contractor. It was by contract obligated to provide all work and materials for this job. Even if it contracts some work out to an independent contractor, Veard is still responsible. If the independent contractor fails to perform, Veard is responsible for getting the work done. The independent contractor is doing work that Veard is obligated to perform under its contract, and therefore is working on behalf of Veard. The same is true if the independent contractor contracts out part of its work to another contractor. Since Veard is the general contractor and is responsible for the entire project, and any subs, even if it's a second-tier sub or an employee working on this job, are working on behalf of Veard because Veard is responsible for the entire job. The exclusion does not require Procentury to prove that Green was an independent contractor for Beard. That's not the issue. The exclusion is worded very broadly. It doesn't talk about a contractor hired by Beard. It doesn't talk about a contractor that has a contract with Beard. It doesn't talk about a contractor working directly for Beard. It refers to any contractor working on behalf of Beard. And in this case, whether Shannon Green was an employee of Patrick Electric, as he alleged in his lawsuit, or whether he was somehow an independent contractor, he's still working on behalf of Beard. In the first lawsuit, and this is undisputed, this appears in Evanston's briefs, it appears in our briefs, Green alleged that he was an employee of Patrick Electric. There's no dispute that Patrick Electric was an independent contractor hired by Beard, and there's no dispute that Procentury's exclusion applies to claims of employees of independent contractors. There's no contention that the exclusion did not apply to the first lawsuit, and that's the lawsuit that Procentury was asked to defend, the lawsuit in which Green alleged that he was an employee of Patrick Electric.
Counsel, help me understand that in what the trial court said, effectively, does that mean that the only people who are not excluded are employees of Beard? Because once you have one independent contractor, you're done with the analysis.
Well, actually, an injury to an employee of Beard is excluded by a separate exclusion.
Okay, well,
That's
let's
not
assume
part of
that's not the case. Okay.
Okay.
I mean, if you took the trial court's interpretation of just that language, just that one phrase, does that mean practical effect of it is it's only employees of Beard? And so then what import does working on behalf of it, and it says any insured, not the insured, but any insured, what does that phrase mean?
Well, when Beard is the general contractor and is responsible for the entire job, then any sub, even if it's a second-tier sub, is working on behalf of Beard, because Beard's got to get that job done if one of the subcontractors defaults. Now, where it wouldn't apply is if we imagine that Beard is a roofing subcontractor, and separately there's a plumbing subcontractor, and they're not vertically, they're related in parallel. They were each hired separately by the owner. If an employee of the plumbing contractor sues Beard, who's the roofing contractor, the plumbing contractor's not working on behalf of Beard. He's doing a completely different job. So the exclusion wouldn't apply to that. But where the insured is the general contractor on the job and is responsible, the contract makes it real clear. They're responsible to provide all work and all materials on this job. So anybody below them who's doing part of the work that Beard is responsible for is working on behalf of Beard. And this is why, under the facts of this case, it doesn't matter whether Shannon Green was an employee of Patrick Electric or an independent contractor hired by Patrick Electric. He's doing part of Beard's work, and therefore he's working on behalf of Beard. Now, it's also important, I think, for the court to understand what's really going on here. Beard settled out of Shannon Green's lawsuit, and Evanston's Insurance, Lakeview and United, took the case to trial and they lost. They were held liable for their own direct negligence. They were not held liable vicariously for Beard's negligence. Lakeview was found 55% negligent. United was found 20% negligent. United is the property manager. Evanston insures Lakeview and United for their own negligence. That's a risk that Evanston covers. So it paid the claim for its insured's own negligence. And at that point, it should have closed its file and moved on to the next claim.
Was that argued during the motion for judgment on the pleadings?
It's not part of the motion, but it was argued at oral argument. But I think this is a background fact that the court needs to understand, because what we have here is a situation where in the second lawsuit, where Evanston is now subrogating for the money that it paid on behalf of its insureds, Beard had no conceivable liability in that lawsuit.
So I can understand that some of that argument at the oral argument is responsive to what the other side is arguing, which is this is not how this is supposed to work. This is kind of outside of normal practice and procedure. But if it wasn't argued specifically, and the trial court's entry only talks about the narrow interpretation of the one phrase in the contract, then are we to look at all this other background information about what makes this judgment entry make sense globally, as opposed to this is the correct way to interpret this phrase in this contract?
It's not necessary to go there. Okay, you're right.
I'm not faulting you for doing that, I just need to understand the argument so that I can.
The purpose of the argument, and here to be very brief, since Beard settled out of the first lawsuit, they couldn't be liable for contribution. Then there's an indemnity claim. They can't be liable for common law indemnity because they were directly negligent. This is not vicarious liability. It's not secondary liability. It's direct negligence. Then we have a contractual, so that doesn't apply. We have a contractual indemnity clause that doesn't apply to United because it's not a part of the contract that includes the indemnity agreement. And we have the clause itself that doesn't apply to Lakeview's own negligence. It just applies. Beard agrees to indemnify Lakeview against Beard's negligence, not against Lakeview's negligence. And if they agreed to indemnify Lakeview against Lakeview's negligence in a construction contract, that's void by operation of statute. So the point of this is that Beard consented to a judgment against it for about $766,000 when it had no conceivable liability in the case. And on its face, it appears to be a collusive consent judgment. And collusive consent judgments are not enforceable.
Counsel, the more I hear both of you present your arguments to the court, I keep going back to the fact that this is a judgment on the pleadings.
Well, yes, but
That's pretty amazing. I'm not saying it can't be done, but I'm saying it's pretty amazing, especially in a deck action.
well, the pleadings, the plaintiff's complaint alleges that Green was an independent contractor for Patrick Electric. And we say, we deny that. But even if it's so, it doesn't matter for the reasons that I said. We have this allegation about Green being an employee originally, and then it morphs into an independent contractor for no evident reason. We've got an insurance policy that's in the record, and we've got arguments based on that allegation and the insurance policy. It's susceptible to resolution by judgment on the pleadings.
Except for, and I realize it was sent back by the Court of Appeals to deal with the allegations relative to the declaratory judgment action. But to Judge Carr's point, and I know we're now moving away from that narrow contract interpretation of that clause, but Judge Carr's point, how do you have a motion for judgment on the pleadings when you have a declaratory complaint?
Well, we've got a counterclaim for declaratory judgment. There's a complaint that alleges Green was an independent contractor for Patrick Electric, even though that's not what Green alleged when he filed the suit. And we've got an allegation in the complaint. We have an answer that admits some things and denies other things, attached to which is a complete copy of the insurance policy. It's a question of contract interpretation, and it's fully susceptible to judgment on the pleadings. We say that because Beard was a general contractor the direct subs and their employees, and even if there's a second-tier sub, they're all doing part of Beard's work, and they're all working on behalf of Beard.
So as it relates to the counterclaim for declaratory judgment, there was no additional evidence, it was all related to what was in the pleadings with the contract attached?
Correct. The counterclaim is the flip side of the complaint. The complaint says, here's what we think the facts are, and we think it's covered. And the counterclaim says, even if we accept your allegations as true, it's not covered. Because of the situation where we have Beard being a general contractor and everybody downstream doing part of Beard's work.
And you said all that in the counterclaim?
Sorry?
You said all that in the counterclaim?
Yeah, the counterclaim alleges that we have this exclusion, and it applies to bar coverage for the claim.
Because to be honest with you, it sounds to me like that's a motion for summary judgment and a counter motion for summary judgment or a response.
Well, and there's really no other facts that are needed beyond what's in the pleading, and there were no other facts submitted to the court. We've got Evanston's allegation, and we say, that's fine, here's the insurance policy. Whether Green was an employee of Patrick Electric or an independent contractor of Patrick Electric is not a material point, because it makes no difference where Beard is the general contractor.
And the contract itself was attached as an exhibit to the complaint?
Correct. Exhibit B, I believe the general contract agreement is part of the pleadings. The insurance policy is part of the pleadings. And the complaint alleges what it alleges. And we say, and the judge agreed with us in the trial court, that it doesn't matter whether Green was an employee of Patrick Electric or an independent contractor. Either way, the exclusion applies. Thank you.
You have 2 minutes, because 6 seconds.
Very briefly, Your Honor, I'm quick. All of Procentury's arguments are well and good, but Your Honor's comments are absolutely correct. The prism we have to look at is the pleadings, and there's nothing more. And a lot of what they're trying to talk about isn't part of the pleadings. If the court looks at the page 4 of the trial court's decision on May 24th, the court acknowledges that we pled Shannon Green was an independent contractor of Patrick Electric, and that's when he sustains injuries. In commenting about Procentury's response to that allegation, he says, Procentury admits Patrick hired and retained Shannon Green to perform work, but denies for one information his status as an independent contractor. So our allegations made affirmative representations which were never contested in the pleadings.
But they say that it doesn't really matter whether you're an employer.
That's well and
Employee
good.
or an independent contractor.
Your Honor, the Procentury argument would be wonderful if the exclusion had the word contractor in it. If hired by a contractor, it doesn't make any difference. But Procentury is left with the language that it uses in its exclusion. And Procentury is also subject to the fact that this court is required to construe that in a manner that if there's any ambiguity as it relates to the unique facts of this case that are pled in our complaint, that we are entitled to have favorably construed in favor of coverage. The only case that this court has been cited to that deals with kind of the situation we have is the underwriter case versus ITG, where the court or a carrier presented that argument and the court said, hey, this is not a summary judgment issue. There's issues of fact as to whether or not an independent contractor retained by a subcontractor can be construed as an independent contractor working on behalf of the contractor. That's what the magistrate rejected the argument that is essentially being made by Procentury today. That's the only case that I could find that really addresses the situation we have before this court. One last point, and I would also submit, we also brought to this court's attention that there's another provision in the Procentury policy. It's entitled the Subcontractor's Conditional Deductible Liability Endorsement. The reason why we think that this is irrelevant, because it contains language. It talks in terms of subcontractors retained by Barrett, the general contractor, and it has the words working on behalf of. And that policy language speaks in terms of written contracts between Barrett as a general contractor and a subcontractor. We think the fact that Procentury treats that same language and another policy exclusion as relating to written contracts, a contractual relationship becomes relevant when this court is asked to construe the same language in a different policy provision by Procentury. Recognizing that we're dealing with a judgment on the pleadings, recognizing that we've pled all the necessary facts that we think we need to make this decision, recognizing that the exclusion doesn't contain the language that Procentury wishes it said, we respectfully submit that this is not a judgment on the pleadings case, and this matter needs to be remanded back down so it can go forward. Thank you for your attention.
Thank you both for your presentations to the court and your arguments. The court will take the matter under advisement and issue a written opinion that will be sent to both of you, as well as released on our website and then on the Supreme Court website. Thank you, Judge.
Thank you, Your Honor.